I have been asked to discuss how paragraph 6D of our 1-to-4 family contract works. What are valid objections to title? When and how can objections be made? What are the seller's obligations to cure objections, if any? And what can a buyer do if the seller cannot cure objections? Paragraph 6D of the contract allows a buyer to object to title exceptions shown on the title commitment and items shown on the survey other than those already assumed and agreed to by the buyer under the contract. Under paragraph 6A of the contract, buyer agrees to and accepts all customary and standard exclusions and exceptions to the policy as enumerated under 1 through 9 in 6A. As specific examples, buyer agrees to accept any restrictions to title if such restrictions are covenants common to the subdivision, 6A1, and buyer agrees to accept any easements created by the plat where the property is located, 6A4. Meaning if all the properties in that subdivision have the same restrictions which were created when the subdivision was formed, or if the easement shown on the survey was created by the plat, then the fact that the subject property has that restriction, or the survey shows an easement that runs right through the backyard, the buyer cannot complain. Because buyer assumes and accepts certain standard exclusions and exceptions, it is important when representing a buyer to discover if buyer has a particular and unique use for the property or wants to build something new on the property that might be restricted by standard and previously agreed to exceptions. For example, if the buyer wants to raise chickens in the backyard of a residential property, then under paragraph 6D, that intended use needs to be specified. Otherwise, a restriction against having any farm animals on the property would prohibit buyer's desired use. If buyer wants to build a pool in the backyard where there is not a pool currently, buyer should insert that in paragraph 6D. Then if an easement created by the dedication plat runs right through the backyard such that it restricts the building of a pool, the buyer can terminate the contract and get his earnest money back. Aside from the customary and standard exclusions and the exceptions enumerated under 6A 1 through 9 and already agreed to by buyer, buyer can make objections to other title or survey exceptions. Buyer is required to make the objections timely or he waives any right to object. Paragraph 6D requires that objections be made on the earlier to occur, the closing date, or a negotiated number of days, whatever you negotiate, after buyer receives the commitment, exception documents, and the survey. Note, the objection period does not run until buyer has received the title commitment along with copies of all the exception documents, which are those items listed in Schedule B of the commitment, and the survey. It doesn't matter that the existing survey may have been received by the buyer at contract execution. Buyer does not have to object to anything shown on it until he has also received the commitment with its exception documents. Objections should be in writing and delivered to seller, his agent, and title company. Once valid objections are made, the seller is given 15 days from that date to cure the objections. The cure period extends the closing date automatically as necessary to cure and then close. The seller is required to make reasonable effort to cure the objections, but the contract specifically states seller is not obligated to incur any expense to do so. If seller fails to cure objection or otherwise satisfy buyer within that 15-day cure period, buyer has an additional 5 days to decide if he wants to terminate the contract by giving written notice of termination to seller within those 5 days. Failure to provide such notice of termination means buyer has waived the objections. The closing date then extends automatically to on or before 7 days after title objections have been cured or waived. These automatic closing date extensions can and most likely will collide with a 30-day close period. Be careful not to overpromise a firm 30-day close. To those of you who asked about the questions about this process, procedure, and mechanics of making title objections, I hope this video podcast answers them. If you need further information, please reach out to me. I'm happy to help whenever I can. Thank you for supporting Allegiance Title.